Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. On April 19, 1973, the respondent accused inflicted as many as 5 stab wounds on the appellant. Stop. The injuries were very severe as will be found from the description. Stop. Para. The appellant had also to undergo an operation. Stop. There is no doubt that prompt and proper medical attention alone saved the appellant from death. Stop. Para. The accused was convicted under Section 307 IPC by the trial court by its judgment dated February 26, 1974 and sentenced to 10 years rigorous imprisonment and also to a fine of rupees 200 in default rigorous imprisonment for 1 year. Stop. Although the accused told his age of 19 years, according to the trial court, he appeared to be aged about 23 years. Stop. Para. The accused appealed to the High Court against his conviction and sentence. Stop. The appeal was numbered as Criminal Appeal number 442. Stop. The injured person also filed a criminal revision application being numbered as 6006 for enhancement of the sentence passed on the accused. Stop. The appeal was decided by a learned single judge of the High Court of Punjab and Haryana on January 10, 1975. Stop. It appears from the judgment of the High Court in that appeal that conviction of the accused was not challenged. Stop. The only point that was argued was that the accused was entitled to set off the period of his detention as an under trial prisoner against the period of imprisonment imposed upon him under Section 428 of the Criminal Procedure Code 1973, which came into force from April 1, 1974. Stop. It appears also from the judgment that the state did not oppose the aforesaid submission on behalf of the accused. Stop. The learned single judge therefore passed the order in the following terms: para. There is force in this submission of the learned counsel which is not opposed by the state counsel. Stop. I am of the view that the ends of justice will be met if the term of imprisonment of the convict appellant is reduced to that already undergone by him. Stop. Having said so, the learned single judge dismissed the appeal, maintaining the conviction, and reduced the accused's term of imprisonment to that already undergone by him, and also maintained the sentence of fine. Stop. Including the pre-conviction detention, the accused served only 1 year and 8 months of the sentence. Stop. Para. It appears the state did not choose to prefer any appeal against the grossly inadequate sentence passed by the High Court. Stop. On the other hand, the inquired person made an application to the High Court for a certificate of fitness for leave to appeal to this court under Article 134 of the Constitution without success, and thereafter obtained special leave from this court after notice to the respondents, including the state, to show cause why special leave to appeal should not be granted. Stop. Para. We have described the above facts in some detail as we fail to appreciate why the state in this case should have ordinarily ignored to take notice of such a grossly lenient sentence. Stop. The order of the High Court was clearly unsustainable even in terms of Section 428 Criminal Procedure Code, as the only set of which was urged for under the section and which was admissible was a period of about 9 months which the accused had served as an under trial prisoner prior to the conviction. Stop. Para. It is also clear from Section 428 Criminal Procedure Code itself that even though the conviction was prior to the enforcement of the Code of Criminal Procedure, benefit of Section 428 would be available to such a conviction. Stop. Indeed, Section 428 does not contemplate any challenge to a conviction or a sentence. Stop. It confers a benefit on a convict, reducing his liability to undergo imprisonment out of the sentence imposed for the period which he had already served as an under trial prisoner. Stop. The procedure to invoke Section 428 Criminal Procedure Code could be a miscellaneous application by the accused to the court at any time while the sentence runs for passing an appropriate order for reducing the term of imprisonment, which is the mandate of section. Stop.